Ladies and gentlemen, welcome you to the book video 7 with my good friend Ron Nielsen. He is the author of The History of Federal Lands in the United States and the Violence of Faction. This book we anticipate is going to become more and more popular by the minute because everything that we're starting to deal with is an issue of extreme contention. Not just a matter of contention, but people are really questioning, they're really starting to question what's been going on. They've been questioning what can be done. They're questioning how we got here. And so I'm pretty happy to be on with Ron to help kind of simplify some of the things that Ron talks about, or at least offer some further clarification to make reading the book a little easier. This video is supposed to be an accompaniment to the people that are reading the book, although if you need to cheat, we understand what that feels like because it is heavily, it's a dense, what did he say? A dense, yeah, anyway.
Information dense,
Yeah,
I was told.
information.
Yeah.
Yeah, that's an understatement. But anyway, not to scare you, I'm going to go ahead and start like I usually do with an overview of what we talked about in video 6 before we move into video 7. Um, and video 6 was from pages, we just covered 21 and 22, so we were really rocking. But we're going to take off from 22 today. But video 6 covered the power of Congress over the territories, Congress having sovereignty, Article 1, clause, let's see, Section 8, Clause 17, with exclusive jurisdiction, the Organic Acts, Congress giving concurrent jurisdiction. Uh, we're talking about private rights. We talked about unincorporation through admission acts and documents of incorporation. People are going to go like, I don't want to know that. But anyway, I've just got to do it. We He talked about a couple of cases. I thought no, he talked about Rasmussen versus U.S. Talked about Alaska's incorporation. Um, we talked about the difference between insular and contiguous, admiralty jurisdiction, and we talked a little bit about the book, The Right of Territories to Become States. So as we depart from video 6 and we move on to this video here, Ron, I had mentioned to you when we were off the air that there were several acts and things, and I wasn't sure if you actually wanted to go into any detail on those, and you felt like we'd covered those before. Is that right?
Yeah, but there is a little bit of an issue that's come up before in debate with people like Angus McIntosh, who's God rest his soul, is not with us anymore. Unfortunately, I think he fell prey to the COVID thing. But I hope his family is doing well. It's one of the things that we had a severe, very heated debate over, and that was that there's an opinion by quote unquote learned individuals and partially emanating from the Sagebrush Rebellion camp or faction, which is it's a legitimate faction. Ammon Bundy's in that faction. I don't say that as a pejorative. Okay, this is not an attack against the man. He's been attacked enough. Okay. I'm just pointing out there are some differences in the factions and what they believe according to this book. So this book sort of lays out the historical documentation structure, and what it does is it brings to the surface some anomalies. One of these anomalies is that the belief from people that are in that faction is that the different acts, like the Stock Raising Act, for example, amounted to a disposal without having to go through the patent process. One of the issues in debate that I had with Angus when we were going through this is the government and the act had a very clear intention, and the intention was that they would make the patent process available to people that they could avail themselves of if they met the criteria in the act and then applied for a patent. The government was not in just the habit of giving away land, except for the original land grant giveaway thing that happened in Oklahoma and some of the plain areas. Um, Now, why is this important? Why am I bringing this up? Well, because that faction and other factions that are somewhat aligned ideologically with that faction, the reason why they believe that is because they don't have the entire history at their disposal of the land program. That's why they believe that. The underlying belief is different than I lay out in the book. The underlying belief of those guys is that when the states became states, the United States government granted all of the land to the state in the Admission Act. That's what their belief is.
But they gave it to the people. It was available for the people, not the states, right?
That's right.
Okay.
That's the component that they're missing. I've I've tried to tell them that. I've tried to show them the documentation. They won't even look at it. So it's just sort of a waste of my time to continue trying. I thought the best thing that I could do is just write. It got to the point where I'm like, okay, just write the book, get it out there. It tells a different narrative. The government's been right to a degree in that they've got their specific um, legislation that creates a disposal mechanism for mining, for ranching, this sort of thing. And there was no automatic grant to the person just by virtue of the fact that they had a ranch. You had to go through the patent process, and it was clear in the Stock Raising Act, and that was in '64, I believe, was the Stock Raising Act. So you have to read the acts. It tells you about the patent process in the act. And so this brings up a huge dispute between all of the people operate. And so, just so that we're clear, Angus McIntosh was a professional federal witness for ranching issues in federal court. Professional
So
witness.
he knew what he was talking about, right?
He knew the laws, but he didn't understand the underlying land program
Oh, I see.
system.
Okay.
Nobody did.
Can I ask a question?
Yeah,
So, relating to the ideologies the of faction, let's say, maybe like the Sagebrush Rebellion folk and some of that stuff. The first thing that came to my mind is if if people are going to engage, then they better make sure they're right. Because
agreed.
if they're not right, they're going to end up suffering what could be some rather catastrophic consequences, right?
Agreed.
So if the general understanding, and I'm challenged all the way, so I could try to pick out and I could pick out a thing. Let's just say you were going to stand and protest in public, for example. I don't know why I picked that. And you were going to stand on the grass, okay? And
The
you
grassy knoll.
strongly believed that that grass was public property, man. But you know what? You were wrong, and you got arrested. And so I think the misapplication or the people's desire to be able to do something because they believe that something exists when it truly doesn't could really have some negative consequences. I can't necessarily say that from all of the things that we've dealt with in the last, 10 years, 50 years, maybe with Ammon, maybe not, that some of those things, some of the reasons why maybe we got hit so hard is because maybe we just didn't know as much as we should have, and we acted more on emotion than we did on facts. Is there any truth to that?
Yeah, there's a lot of truth to that, Tom. And
Yeah.
this is one of the reasons why I'm doing the video series and trying to do more interviews and trying to get the book out to as many people as possible. There's been enough bloodshed here.
Yeah.
We don't
Yeah.
need more. Okay, so let
Okay.
me take that just a step further.
Okay.
Okay, let's say that you're a conservative and you're part of the MAGA faction, and I look, I'm a supporter of the MAGA faction. Okay, I'm a huge Trump supporter. I believe that Donald Trump's probably our best shot at president to try to fix some of this stuff because he went to war against the administrative state, right? So his policies are right up my alley. This is the kind of guy I want leading the nation for the next 4 years
Mm.
in this coming election. So, having said that, there's some things that the conservative faction needs to understand. It might think You might think, and it might seem like a good idea to drive into Washington, D.C. and run amok at the Capitol, inside the Capitol building and all in the Congressional building.
Hmm.
It might seem like a good idea until you read Article 1, Section 8, Clause 17, and the Home Rule Act. In which case, if you read both of those, you would see that Congress and Washington, D.C., Congress has that under its exclusive power. That entire area is under exclusive jurisdiction. Here's what that means. We've covered this many times so far in these videos. If you're in one of those areas, there is no guarantee of private rights. That means they can hold you as a January 6th prisoner in a gulag, and they don't have to worry about giving you your private rights. That's what that means.
Well, what's interesting then is they wouldn't necessarily need the NDAA either then, unless they were operating on places that weren't under exclusive jurisdiction, right?
Yeah, see the
I don't want to get off into the
NDAA.
weeds. Sorry.
Well, no, it's these things all tie together. It's like,
Right.
okay, where would you expect the NDAA to operate? Well, it would be operating any place that's exclusive.
Mhm.
Why? Because the government's constitutional power is within its grants of power in the Constitution and on its territorial power on its territory.
Mhm.
So anywhere where it's got territory and anywhere where the government building operates as this is what they call a federal enclave, meaning it's a government building under 1817 that's under the government's jurisdiction and they
Mhm.
can apply that power to. So that's where the NDAA is going to operate. Now, it gets a little tricky when the government's doing its business domestically because you got to try to figure out, well, nobody's tried to figure this out, right? So this is nascent. This conversation is nascent. It's never been had before as far as I know. And that is where the government is operating, can they run that operation in that area? Meaning we have to identify whether it's exclusive or not.
Mhm.
Nobody's having this conversation. I've seen people like Mark Levin try to have this conversation, but he doesn't know this component. Nobody knows this component. We've missed it. I missed it. We all missed it until I dug into it.
Mhm.
So it's not just the NDAA that may or may not be operable in a specific area, right? We have to go, all right, what about some of these other national defense or national intelligence apparatus pieces of legislation? Where are they operative, right? Because what we're seeing now is that the government is trying to apply this exclusive power across the United States. And one way it can circumvent that, the normal constitutional restrictions, the only restrictions against the government, let's just say it this way, the only restrictions against the government are two, where the Supreme Court's limited the reach of their power and where private rights are applicable. If you remove private rights, you have to rely on the Supreme Court to roll it back, and they might not. I don't look, it's a really bad idea to not go after the loss of private rights domestically simply because we're not aware that the government is circumventing that restriction,
Mhm.
right? That's the number one restriction for rolling back this administrative power. If you were going to try to rely on the Supreme Court to make good decisions all the time, I
Yeah.
just think that's a losing game.
Well, so then that forces me to say that so if we were talking about rights are dependent on SCOTUS with uh in the realm of exclusive jurisdiction, then the one thing that I would naturally come up with, and most people, simpletons like myself, would go, well, the Supreme Court can't give rights. It's like, well, yeah, they actually can, right?
Okay, so there's two type of rights. There's three type of rights in our system of government. No, and again, I never hear anybody explaining this, and I hear a lot of people talking about civil rights. Okay,
Mhm.
but according to the Supreme Court, there are three types of rights. All right, you can actually narrow them down to two types. From a legal analysis, you can narrow them down to two:
Okay.
private rights and public rights. What is the difference between the two? I will tell you. A private right are amendments 1 through 9. A public right, sorry about the middle finger. a public right, a public right
Nice.
is any right that the government legislates for you, meaning it was a right created out of legislation or policy.
So that's also a civil right, right?
It could, yes,
Okay.
yes, that's also a civil right.
Okay. I always
But
wondered about that. I'm like, they
when
don't, they're,
you're in, yeah, when you're in court, when you're in an administrative court setting and you're having this argument with the Department of Justice, for example,
Mhm.
the Department of Justice is going to use the term public rights
Mhm.
to cover civil rights, legislative rights, etc.,
Mhm.
because they're all considered public rights.
Right.
So, what is the difference between a public right and a private right? A public right does not act as a restriction on government action. It's more like a privilege and immunity. A private right, we know this from Barron versus Mayor of Baltimore. A private right acts as a restriction on government action. Period.
And so you said that, hang on a sec. Um, you said that that was amendments 1 through 9 or
Amendments
article.
1 through 9. You
Okay.
can count the 10th Amendment because the 10th Amendment says to the states and or the people, right?
Right.
But the specific private rights for human individual private rights are 1 through 9.
Well, this is a fan that it, I'm so glad that we covered that because that's been a long-standing question for me as much as I've studied, and it's great to be able to have that clarified from you. So if there was nothing else, the video was good and just on that alone. So thank you for that.
You're welcome.
So did you want to continue on with that? I know that we were going to start with uh you talked about the fact that debt was a driver for land policy.
Yeah, so we got a lot of debt in the United States right now, and one of the things that we keep doing as a nation is we keep borrowing money to pay the debt. We're not really even paying debt down, right? We're just borrowing money, creating more debt. Um, that's because we moved to a fiat system after, at first it was a gold and silver based system. And then in 1912 or 1913, I guess, is when we rolled out the Bretton Woods Agreement, and then we rolled out, well, Bretton Woods came later. Well, no, that was later. But anyway, 1913, we had the central bank situation. That's when the Federal Reserve was created. Creature from Jekyll Island. We know that from that excellent book. Um, and so you have this Federal Reserve system. Now you got this fiat money system, and it's a debt based system. Prior to that, it was a gold and silver system. Okay, so what is the issue with that? Well, when the national debt prior to 1913 is being partially settled by the sale of land and then the commercial activities from the citizen who buys that land to add to this commercial system. It literally rearranges the entire commercial structure of the United States, and the money system that we're utilizing for these activities is now based on debt. So while we have a system before that discharges and settles debt, we switch to a system that now encourages debt, the creation of debt, right?
Mhm.
So it was a major change in the commercial and the way that the commercial system was going to operate. From that moment, the United States didn't need to discharge and settle its debts anymore. It was more concerned with creating debt, because when they create debt, you create money in the system.
And it
And it
empowers the
wants,
Federal Reserve, and the Federal
yep,
Reserve incrementally gains control.
that's right.
Right? Okay. So I know that I probably should have had you define that earlier or maybe later. There are some things I think that are better understood if they can see things in like some sort of order. And
Agreed, agreed. I think a lot of this stuff, and that's how I tried to write the book, is in that logical progression that a human mind, I would think a human mind would go through this logical progression. And I tried to be as close to a natural, cogent, logical progression as I could do for
right.
myself, and hope other people could see it as well.
Right. So when you were, there was some question early on. I had written down the word process because I think I was just looking for an outlined process where um uh oh, okay. So when you were talking about the different acts that were regarding they thought that the acts were disposing of land without the patent process. What that process actually is, I don't know if it's outlined. It's at least not bullet pointed, and I like bullet points, so no.
Right.
So
You
it's like,
talking about the
okay,
patent process?
yeah, so it's like okay, or maybe even further than that. Maybe it's not the patent process at all, since the topic is land disposal, right?
Yeah,
So
well, in the book, Tom, what I do, and I'm glad you brought this up because it was escaping me, but one of the things that I found as I was going through the acts, the disposal acts, is that when you watch, and I put a list of the acts, and at the end of the acts, or each one of these that I have a list of, I would put either disposal or ownership, a legislative principle, right?
yes, you
So
did.
when you go through these acts, by the time you get to the bottom of it, just before the passage of Flipman 76, you
Hmm.
start seeing this ownership principle
Right.
manifest.
The data, the date,
Pre-Flipman,
the date puts us also on the beginning of the New Deal era, ironically.
right?
That was the Taylor
Yeah,
grazing. Okay.
yep,
All right.
yeah. Yeah,
So,
the 1934 Taylor Grazing Act, that was an ownership principle act. And you saw the ownership principle being asserted in 1934. So the passage of Flipman 76, it's like it was a no-brainer that that was eventually going to happen.
so is there, would it be too much for me to ask, if you could briefly define the difference between the disposal, uh, what was it? Disposal. What was the other one? The other one was just ownership, right?
Yeah, disposal and ownership are the two
So,
policies that work here. Yeah.
okay, can you give us like the Reader's Digest
Yeah,
version of what that the
absolutely. Yeah.
difference
So
between that?
the land program's creation by the men who created the program, the intent of the program was that the United States was not going to hold large portions of land, they were going to dispose of it. Now, the term disposal meant sale. They could sell it, they could give it away, which they did. They could create programs like the patent process where they could do a land grant if you met certain criteria. So they had a lot of different ways to get rid of or dispose of the property. The intent of the land program is not what we have now. What we have now is an ownership. They seized ownership, but you could see from the Louisiana Purchase when the arguments were going on about the whole purchase of the Louisiana territories from France, they were debating this and they were like, look, these are our properties, the property of the 27 states in the Union at the time. Those are our properties. That's what they were saying. So from there, my logical mind goes, well, geez, you're way ahead of Flipma. Obviously, this thing's going to grow. And it did grow. It grew from there. So by the time you got to Flipma, everybody naturally, all members of Congress go, well, it's natural for us to assume ownership because we think that was the intent of the program. No, intent of the program, and you can clearly see that in the original documentation. But look, we covered this in previous videos. The United States government didn't even create enabling legislation from the Louisiana program onward. Didn't even bother. It knew what it was doing. There's nobody that's going to be able to read my book and try to come out publicly and say, you're off your rocker on. There's nobody that's going to persuade me that the government didn't understand that it wanted to adopt the reason for the lack of enabling legislation for Louisiana Purchase on was because they wanted ownership.
We could see that today. I mean, it's definitely nothing they do is, I would have a hard time believing that nothing they do is on accident. And the
No.
fact that they're incrementally growing their control in the states and over the people and all of these kinds of things, when you ask the average soul, people would automatically admit, no matter what political affiliation you have, is, oh yeah, the federal government owns all land. So it's just become this general, understanding that it's just so far from what it should be.
Yeah,
So
you're not, nobody's going to convince me. that there's, well, it's just, don't attribute to conspiracy what you can attribute to incompetence. You hear this all the time, right? Well, when I hear that after, my research and writing the book, I'm like, no. Now, would I say this is a conspiracy? Well, by the strict meaning of the term conspiracy, that would be the commission of a crime, or the planning of the commission of a crime by two or more people. That would be the definition of a conspiracy. Now,
Sure.
do I think that members of Congress were planning on committing a crime? No. No, this isn't. This is a civil matter. The land issue is is a political matter. It's always been a political matter.
Hmm.
I mean, the whole idea of the creation of states, other states in the Union, is purely political,
Hmm.
man. It's not a legal matter. It's not a. There's no conspiracy here. It's just strictly political, man.
Yeah. Well, I think when we can go back far enough and we can understand the establishment of the 13 colonies, where the governors actually got to choose their state religion. So, I mean, you'd have there has to be some similarity,
Right.
between all that. So I get
So
that for sure.
so if I was using the deter, if I was saying, okay, the definition of the term conspiracy, is this a conspiracy? I'd say no, it's not by the strict definition of the term. No.
Right. Right. So, you later on, let's see, you were talking about territorial governments going on strong. I had written a note. The previous process under the Northwest Ordinance was to pass organic legislation. Again, I'm thinking, okay, I just wish I had some bullet points here. Um, is there a simplified process involved in this where you could tell us what the what the process was? Like they had to have, 5,000
Yeah.
people, then they had to have
Yep.
organic legislation, then they became a whatever. Can you go into that for a minute?
Yeah. So the whole idea was this. Okay, the United States government would carve out the boundaries of a territory. Let's say we're in the Northwest Territory still, pre-Louisiana Purchase, and we're dealing with Indiana, which was the first state carved out. So we carve out Indiana. So we got the state, it's carved out, got boundaries for it. So the whole idea was to have the inhabitants of the area
Mhm.
organically morph into a state over time, right? So you'd have so as soon as the Northwest Ordinance mandated, as soon as you had a population of 5,000 free male inhabitants, that would allow representation in the territorial legislature, and that would count toward the representation in that legislature. And they had to hold 200 acres of land fee simple, or 50 acres freehold. Here's what that meant: 200 acres fee simple would be like a stock raising grant, or act where they're leasing land from the government to raise cattle. And then 50 acres freehold is that you have patent or title to that land. That's what those terms mean. You had to be a resident in the district for 3 years. You have to have been a United States citizen, or a citizen of one of the states, for 3 years. But they weren't states; they were territories. Okay, so that's just a bug in the system. So there's no way to address that. It's just, it is what it is. Um, the whole idea with this territorial system was that Congress would not have direct oversight and tutelage over the government of the territorial legislature. They would organically, with the help of Arthur St. Clair, right, act in a sort of a big brother. I would
Mhm.
imagine the term big brother, big brother to the emerging state, this fledgling territorial system in Indiana, and he would assist them with his territorial government, would assist them.
I
Once it
see.
reached a certain status, it could apply for statehood. But the whole idea was to allow that system to raise itself up, to train those inhabitants on how to run a representative style of dual federal government.
Nice.
It was a training program.
Well, no
And
wonder
once
the feds
Congress,
didn't want to give up their land.
right?
That's crazy. All right,
Yeah.
so you
So
in?
really quick, and I'll finish this up. Once
Okay.
they got to a certain level where Congress felt and believed that they had achieved a level of representative style of government mastery where
Mhm.
their representatives would go into Congress and contribute without being considered um, unequal to the task, right?
Mhm.
Because let's just lay this out. Running this system of government is a little more complicated than running some of the other systems at the time. More complicated. So you didn't want to show up as representative of the system and have zero idea of how it operates when you get to Congress. That would have been bad. That would have been bad.
Just seems like that's kind of what's happening now.
That's what's happening now because the system has changed from this the government not taking a direct tutelage over the area to Congress now and has since the Civil War taken a direct tutelage approach.
Right. Well, and now they operate in this vassal state arrangement, which would not only, I don't know if exacerbates the right word, but where the federal government exercises its exclusive jurisdiction, keeping the states in an inferior position, right?
Yes, and that's the point of the cooperative federal model now.
Hmm.
That's the point of it. They implemented the cooperative federal model to do two things. One, to run counter to the narrative that was laid out in the book, The Right of Territories to Become States. They needed another model of federalism because the federalism model that that the United States was using at the time, the winners of the war, the northern states,
Hmm.
felt like that dual federal model was the problem. So they had to create a new model. They created the cooperative federal model, and they did that based upon the way that they were creating territories. And let's get something straight. The United States, the CIA, going into other nations and tearing down their governments and building new governments, they're the most skilled people in the world because we've been doing it for over 230 years. By the time we were done with the land program, the most skillful people on the planet of creating governments from scratch
Hmm.
was the United States system. They've been doing it for forever.
Wow.
That's how we built the United States. No wonder why these people outsource to foreign areas. They go, "Hey, we've been doing this domestically. Let's go do it." And
If we're
wherever,
gonna if
right?
we're gonna overthrow the Ukraine in 2013 and establish our own government, why is that such a concern to people when we've been doing it for 200 years?
Exactly. What people don't understand the
I
history of the
was
land program. Going, geez, we are skilled at creating governments, man.
Well, I was floored. I mean, I had heard about, I'd heard about, our involvement with Israel and Ukraine and of course everywhere else. And I was very upset because I had this idea that, our Constitution was what it was. There was really nothing else. There wasn't this land program. There wasn't anything that was, there, all of these internal workings that we're now starting to realize once we delve into the issue. I mean, I still believed in the rights are from God and that's the only kind of rights. There's no such thing as civil rights and the Supreme Court can't give rights. And I mean, I'm off and I'm believing this stuff and I'm like, yeah, man, and so it's a sad reality and it's actually more difficult now as somebody that speaks publicly as often as possible. Um the the education that I'm getting from you is causing me to pull back. And it's because, and I hate to say this, but it was something that I honestly believed because I had read it from an original source document that I couldn't be wrong. And when you have that kind of confidence, it allows you to do things that you could otherwise not normally do. Well, now
Right.
with this information here, it's extremely difficult to be able to say, yeah, you remember all that stuff that I actually had told you for the last 15 years? Well, there's actually a lot more to it than that. I honestly don't even know where to go. I'm happy to learn it all. It is upsetting, and so I don't want people to think that, I mean, knowledge is power, right? So you have to think, well, as much knowledge as you're
Indeed.
going to get, you're going to end up having more power. So try not to focus on, on the woe is me kind of a thing. Don't make this about yourself. Just carry on and just continue to push on because
I'd
I
like to
think,
say something real quick. I think what I would like people to focus on is what can we do with this information,
amen.
right? Because
Yeah.
with this information, we have, we will have in time when we have a group of people that understand this really well, we will have a mastery over the intent of the system beyond the people that are running it now.
And therefore we'll be the brilliant experts.
I'm just saying that you get a group of people that understand this stuff really well and know how to navigate within it, from the beginning of the country, and they understand everything that happened till now. And it's like, okay, there's a series of things that we're gonna have to address
Mhm.
moving forward. And one of the things is, okay, so the North and even the current military industrial complex, it's very clear to me, and I think many other people, that their belief structure is pretty much the same as it was when the right of territories to become states was written. They believe that the conservative faction, who very much believes in dual federalism, believes in states' rights, they see this as a resurgence of the same thing that created the Civil War. That's what they see it as.
Mm.
That's why they won't tell you this, but there's two things that tell me this. Number one, there's been a resurgence in the buying of that book. That book was going to go bye bye. The last time I looked on Amazon, it was a hot seller and going for big bucks.
Which book is this?
The right of territories to become states.
Ah, right. That's on my list. I
Yeah.
should probably get it sooner than later, but yeah,
And
well,
so that ideology that um that guy had, that commander had, it hasn't gone away. It's embedded in the system.
mhm,
And so now you got the conservative faction rising. Donald Trump's a leader of this faction, and this
mhm,
faction's gaining power, and they see it as a direct threat
threat. Mhm,
in a potential upcoming civil war. That's how they
yeah.
see it.
Well, that's right. Well, I'm looking at it from the federal government that incrementally is taking more control to be able to institute uh, globalism, and they don't want their narrative challenged, and so they are. It seems like they're much more sensitive against counter narratives to theirs than they ever were before. We're seeing political prisoners and things of that nature, or maybe people are
Yes.
stepping on the grass, thinking that it's public when it's actually private. Who knows? It's definitely a concern. So you mentioned in the book, let's see, we talked about the vassal states again, which is important, so I keep bringing it up. It says that the states and the federal systems had to be the same. Do you know what I'm referring to? This means that each state's political subdivisions were to work in concert with the national government, which means the system of government had to be the same. Can you explain that?
Republican form of government. This is
Yeah,
a
man.
great segue to it.
Yeah.
All right. So that's why the term Republican form of government was written in the United States Constitution, because the land program created states. And in the creation of those states, they had to create Republican forms of government. And the best way to look at those is that those systems, the state systems that they were creating from scratch, were modeled off of the Eastern states' systems. That was the model. This is what the founders called republicanism, Republican form of government. Not a Republican government, Republican form, meaning that it's got Democratic elements and Republican elements to it.
And
It was a
monarchical,
Republican form.
right. And so we had like the founders that envisioned they had, the fact that we think that we're as brilliant as they are is kind of funny. But
It is.
so this is what you're talking about when you talk about they where is that? Oh, sorry. That was rude. Um the So the Republican form of government, I think when I had read something They were talking about, well, they used they had they had seen all of the errors of the different forms of government. And in the creation of this Republican form of government, they wanted to be able to use parts of a monarchy, parts of a democracy, parts of, these other forms of government. That's what you're alluding to, right?
That's right. Yeah.
Okay.
And what they did is they implemented them in the eastern states first before they ever acquired the land. And then they had the Articles of Confederate Government, converted all of the colonies into states, modeled all of their state government systems off of this republicanism style government as they were learning how to do it. By the time they had drafted the Constitution, they had to do a little bit of state rearrangement, a little bit here and there, but they had
Mhm.
pretty much kind of perfected it. So they kind of knew what they were doing a little bit. So once they had crafted the Constitution, they had settled on this system. They had them already created in the eastern states. And so they said, okay, here's what we're going to do. Our land program, we're just going to redo what we've already done. The models in the states, that's the system, a government that we want to outsource. And so we call that nowadays outsourcing democracy.
Nice.
Only we do it at the point of a gun. But
Okay, I have a question then. So then, my common understanding, my constitutional understanding, somebody said if you read 9 books on a topic, you're an expert. So I guess I'm authoritative source. But in my constitutional understanding, the Republican form of government, and I'm looking at we're talking about, the federal government believes they created the states, and the states, they bow to their sort of vassal state, deal, and they're like, oh, okay, yeah, as long as you keep giving me money, we're good. Um, so is it correct going into history that before the federal government was created, that the 13 colonies actually were the mechanism that created the federal government?
yes.
Okay, that's good. Okay, good. At least I got one thing right. That's not disturbed. Okay, good. Now we could just start going back from there. Okay, so once that's true, so the eastern states you're referring to are the original 13 colonies, and maybe at some point some more that had advanced over time, right?
So what area of time, if we're talking from the beginning, it was just the 13 states.
Okay, so we had the 13, and then they expanded westward and whatever. Um, but it wasn't until the federal government was created that they ended up modeling the the rest of the land acquisition according to the eastern states. I'm assuming because the federal government was the only one that would have jurisdiction beyond the 13 states, right?
Yeah, I think what you're asking is like for a time frame, like okay, so Arthur St. Clair in 1787 goes into Los Santaville and in Cincinnati, Ohio, and he creates the territorial government. So they were going to carve Indiana out first, but they had to wait until they got this new Constitution drafted. So after they drafted the new Constitution, then they went to work uh, building Indiana because by the time they drafted and ratified the Constitution, what they had then is they had agreement between all the states that they were going to model the new states
Okay.
off of these eastern states, and they made sure that all the eastern state structures matched.
Okay. That makes sense. That makes sense. Because and the other thing too, I guess, since we're talking about forms of government, is I'm looking at the intricate nature of what we're seeing with with our form of government really at every level. I mean, we look at the federal government, it's got an executive, it's, the legislative, the executive, it's got the judicial. You go to the state level, it's got the same thing.
Yeah,
And so, and that I think is a good thing, personally, as long as people stay in their lane.
right,
But you got to
right.
understand it to do that. And so, but what's really interesting too is that, and of course, this might be a subject for a different time, but it's something that constantly comes up. And if it comes up to me, I'm sure it comes up to others, is that the states, the counties and the cities even have that mimicked form of government like the states and the federal government do to some degree, right?
Yeah. So what
I mean,
we've
some are
done with
quasi this and quasi that, but generally speaking, um, that is kind of the same. And I don't know if I'm going down a rabbit hole, but I just thought putting the final nail in the governments. That would probably be a good thing to mention.
Yeah, I think the creation of the counties sort of was just a natural consequence of trying to organize the states into more, because the government had really built an administrative apparatus, right? So
Mhm.
they counted on the state government and the federal government simply being administrative functions for the commercial activities of the citizens of the United States. And then using the lawmaking power and the regulatory power to make sure that commerce was smooth throughout the United States, that we could have foreign commerce and this sort of thing.
Mm.
So when you look at the intention of the land program and creating that, right? So this is where everybody that's written on this topic, absent the land program, doesn't have it right. Without the land program, you cannot understand how the United States commercial system was built to operate.
Right.
They knew when they crafted the Constitution, they knew that the additional states were going to create this monster commercial system because the land program was predicated on it.
Mhm.
So when you look at the system that way, these state governments, which is why the land was not going to be given to the states. They wanted the state administrative apparatuses to be as small as possible and just powerful enough to aid the citizens' commercial activities. Same with the federal government, just powerful enough and large enough just to aid the commercial activities of the citizen.
I got a better idea. Let's just do the opposite.
Well,
Sorry.
they figured, well, so what happened is that these commercial systems rose up, became so powerful that created public private partnerships, seized control of Congress, created a military dictatorship form of government that what we have now. And we ended up at the end of the Civil War, that's what we ended up becoming is a oligarchical military industrial complex uh, or military dictatorship for profit.
Right.
For profit.
Right.
But the most powerful corporations raised up and just seized control of the system. All really just to get rid of competition
Hmm.
and to control the system.
We're good at that. So you go into,
So the
go ahead.
go ahead. Well, I was just going to say one more thing. So the main benefit of the system was also its main downfall.
Mm.
So
So you have territorial legislatures were then composed in this matter under the Northwest Ordinance. The governor was already in the executive position. Um, the governor would give away to the new governor appointment once Congress passed organic legislation. So this is the beginning of a process, right? So if I were
yeah,
to try to bullet point some of this, like we tried to do earlier, I don't know why I'm focused on the bullet point. Maybe I'm just thinking if I could list it, it would be easier to visualize. But
sure.
if Arthur St. Clair was the governor for the Northwest Ordinance, he had the power and the authority to be able to, you know, to carve out chunks of land that he would give away
Well,
to a
so he
new.
was working with Congress. Congress was doing the carving, right?
Mhm.
But they were doing it with the advice and consent of St. Clair because they needed his help to pull this off.
Okay.
So they
So
were all working on it together.
so then so so one governor would transfer once this land was carved out, this one governor would transfer
Yeah, so
power.
this is the pie scenario, remember?
Right.
We're talking about the pie.
Hmm.
And another way that you can look at this is through the appointment of governors. So you carve out, so you got this huge, massive territory, and then
Hmm.
you carve out a little chunk of territory, give it a boundary condition, and then you appoint a governor to it. And as soon as this territory moves into statehood, like Indiana,
Hmm.
becomes a territory, and then it moves into statehood, and then the governor of Indiana, you can't have two governors of the territorial government at the same time. You can only have one.
Hmm.
So by the time they appointed a governor for Indiana, um, that territory is moving into statehood.
Okay.
So now you have Indiana. It's got its own governor. He's elected now through the election process in the state. It's a state that's admitted into the union. There's not two territorial governors, there's still just one. But now Indiana and the governor of Indiana is now assisting Arthur St. Clair in carving out the other states.
Okay. So if I understand this correctly, the Northwest Ordinance, when was not to give to states, gosh, I don't even know how to say this. I was going to just not say it, but it's too important. Um, the pie scenario would mean that they were to be carving out the land for the states, but wasn't the Northwest Ordinance that the land wasn't given to the states, it was actually given to people?
Okay, so let's see if we can work that out a little
Is
bit
that
here.
right?
So you're right that the
Okay.
land was predicated to be at the disposal of the people of the United States. But you had to, so the government knew that it had to give the states some grants of land to operate its business on for schools, prisons,
So once
its
it
own.
became a state, it was maybe transferred to the people?
No, no, the land was still held. Okay, so let's just take Indiana. So this is how it went. So Indiana moves from territory to statehood. There's still a whole bunch of federal land in Indiana. But what the government is doing with that land is it's selling it and or moving it through its grazing act, its mining act, and disposing of the land. It had already taken care of the grant of land to the state of Indiana, but the remainder of it was up for sale from the federal government. So when you look at Indiana, there's only little pockets of federal land. They
Mm,
sold it all to citizens.
okay. So at the same time that it was kind of like I'm trying to think of it in simple terms. The Constitution talks about, erecting needful buildings and things like that. And it was just specific things related to the federal government. That was given or whatever allocated to the feds under arguably, exclusive jurisdiction at the creation of the states created from that pie scenario. Then the rest of the land was given to the people.
Yeah, so so you had unappropriated and appropriated land is a good way to look at it. We
Uh-oh.
can call it incorporated, unincorporated.
Okay.
Let's the terms incorporation, I think just really people have a hard time with it. The Supreme Court of the United States had a hard time with it. So let we're, we're not I don't want to continue the confusion. So let's just look at it as appropriated and unappropriated. All right.
Hmm.
So as we're using Indiana as our example here. So Indiana comes into statehood. There's still a whole bunch of unappropriated land in federal possession. They're selling it. They're giving grants to patent holders for mining, for ranching, for logging, right? This sort of
Right.
thing. And pretty soon it had disposed of everything except for what it was going to hold on to for the purposes of buildings, military forts, this sort of thing, needful buildings. So when the government was first operating its program underneath its legislation, it abided by the mandate of disposal. It abided by it. You can clearly see that. Just go look at a map of the eastern states. You see that very little federal land.
Right.
So they were abiding by the disposal mandate. But when they got to the Louisiana Purchase, that way west of the 98th meridian, they didn't have any enabling legislation to force them to do that anymore.
Wow. And thus the ownership principle reigns.
Thus, the ownership principle now takes over.
Well, that's good. You talked about let's see, the new model would be organic acts, and I don't want to beat this thing like a dead horse. I just want to make sure I understand it. Um, Listed in the book, the organic acts of the territories, they had no direct legislative military government to protect them.
Let me
Um,
explain that because that might need a little explanation. What I
okay.
mean is no direct legislated military government to protect them. I'm talking enabling legislation. So, one more time. In the Northwest Ordinance and the Southwest Ordinance, you had legislation and it mandated Arthur St. Clair as a commander in chief. It was legislated, man. From the 98th meridian, from the Louisiana Purchase to the west, there was no legislative mandate. There
Okay.
was no governor of the territories with a military to protect them. Now, they still were running they were still running the military in the territories west of the 98th meridian, but they were doing so with no legislative mandate.
Wow. I'm not sure what to even think about that.
Well,
Um,
there's a
yeah,
reason why the federal government has not been open and free and open and transparent with its land program, because if the people knew what I have written in this book, that this is what the government did, what do you think they'd say?
yeah.
The government's at an all-time low in favorability of the people right now, and I don't want this to come across as we need to be less favorable toward the government. That's not this at all, right? The
Mhm.
government mostly did its program up to the 98th meridian 100% constitutional and legally.
Right.
From then on, it was just winging it. It was a free for all. They just did whatever they wanted to do. Um, we I don't want to create more problems for the government. One, because I don't want to get on put on a list, and two, there's no need to do that. We can fix this, right?
Hmm.
And get a resurgence of faith back into the United States government. But the problem for the government is it's going to lose some things in the process. It's going to
Hmm.
have to. It can't keep holding on to the exclusive power domestically. They just
Hmm.
can't, right? You
Yeah,
cannot have any area inside the domestic United States where there is no private rights applicable. I'm sorry.
it's true. And I'm glad you said that because that's one thing I've believed too. So I'm glad I didn't have to change my thought in that. So
Yeah.
you had there were several dates here. I wasn't sure if they were important. If not, I can just mention them and move on because it's part of the book. But in 23, you mentioned on October 3rd, 1803, Congress ratified the treaty with France, taking possession of the Louisiana Territory. March 26th, on March 2nd, 1805, March 3rd, 1805, Congress passed three acts dealing with the Louisiana Territory. The first in 1804, creating a territorial legislature. Now, to me, I'm not all about that. I mean, I find that a little bit confusing because I don't have the background that you do. Is there, if you had to squeeze that down into what simpletons like me would need to know from that, or is it just a matter of fact? Is there something significant that we need to gain from that?
Well, which part? Because there's a few elements there that I could explain, but I'm not sure which part is causing the difficulty.
I'm not sure either. I think that when you talked about the first act that created a territorial legislature, governor, secretary, and judiciary under the control of Congress. This was the Congress's first departure from the Northwest Ordinance. So I'm still back at video one going, okay, so we have the Articles of Confederation, we have the Northwest Ordinance, we have these acts, and we've got these organic acts, and we've got these enabling acts, and now we have this Congress ratified a treaty with France. It,
Hey, remember earlier when I think I understand where you're going with this now. So you remember
okay,
earlier when I was talking about there was no legislation for the government's land program west of the 98th meridian?
yes.
Okay, that's what this is saying here. So let's just dig into that a little bit. Um, I'm just going to read it. Unfortunately, the court misses the point here. Louisiana properties were to be organized under a different program than the Northwest Ordinance established. The unorganized territory that remained after the initial organizing legislation, and what I mean by that is the initial organizing legislation was the Northwest and Southwest Ordinances,
Hmm.
was put under Indiana's tutelage, which made sense seeing that Indiana was the only organized territory in 1803 in the Northwest Territories. So Indiana and the governor of Indiana was active in trying to assist in the organization of the territories, right? So the carving of the territories out so that they could eventually become a state. So that was the process. You had to carve it out, and then you had to meet all these requirements, and then they could apply for statehood. And usually that took 20, 30 years or something like that. There was a time frame associated with it. Um, and then the act goes on to state that the said district of Louisiana shall be divided into districts by the governor, under the direction of the president as the conveniences of the settlement shall require. So the governor of the territorial government, Arthur St. Clair, was collaborating with the president of the United States, dividing the unorganized territory into unorganized territories after the Louisiana Purchase. So not only, so I think by 1803 they had already organized, which is to say that the Northwest and the Southwest territories had been carved out. And then Arthur St. Clair went to work assisting Congress and the president in carving out. The very first thing they carved out of the Louisiana territories was New Orleans.
And that's where I
And
was
so he
going
was
next.
assisting in that process.
Okay. So now to further complicate issues, I'm thinking, okay, I'm thinking Articles of Confederation, Northwest Ordinance, Constitution. I'm thinking, okay, the Northwest Ordinance, um, by enabling legislation, created the Southwest Ordinance. We have the Ohio, right? The South of
Yeah.
Ohio or whatever it is. And
Yeah. So you
now
have the
and
Ohio and the southern areas, two
and
different
and
governments.
and now we have this Orleans Treaty.
Yeah. So
And I'm
and
like,
okay,
oh
so
no.
let me explain that difference. So you have the Northwest Ordinance and the Southwest Ordinance. So
Right.
these are two specific governments. So instead of thinking in terms of ordinances, think now in terms of governments, right? You had
Okay.
a North government and a South government,
Mhm.
territorial government. At 1803, they disbanded that model. They weren't going to do a territorial government anymore. Now what they were going to do is carve out a section directly from the President of the United States and with the help of Arthur St. Clair. And instead of it being underneath the tutelage of the territorial government, it'd be under direct congressional tutelage.
Okay.
This is what the founders were trying to avoid. They did not want the newly created states to be under the direct influence of the government for political purposes.
Right. Wow.
Now, if you go read Federalist 78, you'll see what I'm talking about. Federalist 78 talks about these judiciaries that were being created in the territories. It doesn't specifically name them, but that's what it's talking about. And it's saying, look, we gave Congress, Article 1, that's Congress, Article 1, we gave Congress the power to create these courts. However, we cannot have them under the direct tutelage of the government. That's why they created the territorial government to be the direct tutor.
Mm.
That way, there was a big brother. There was a buffer between the government and the emerging state, a buffer zone. They removed the buffer.
So, contrary to what we believe, oh gosh, um, you know, it's kind of planted in my mind about, the separations of power and the checks and balances and things like that. So we would believe that through basically what I've read is been that the concern that they had was their understanding of, tyranny, right? From an oppressive king or, historical governments or things of that nature. So the separations of power would seem to be rather important. And so are you
Yeah, well,
saying
that's
this
what
was
I'm talking about here, Tom. Yeah.
are we saying that this is something that Federalist 78 supports, or is this a deviation from that desire for the separations of power?
Okay, so once again, the Federalist Papers are the operator's manual.
Right,
What they're doing in these papers is telling you how they designed a system to operate. In
right.
78, Hamilton is saying, we built the system so that we could work. How's a good way? I'm going to paraphrase what he's saying in 78. He's saying, watch out for the merging of the these courts with any of the branches of government.
Mhm.
Watch out for that. That's not what we had intended. And in 1803, our wise people running the government said, "Well, we're just gonna do it."
So in other words, what he was saying, if we were going to use your words, is that he was warning us about them exercising exclusive jurisdiction. Would that be fair to say?
Um, Hamilton's not warning about the use of exclusive power
Hmm.
necessarily, but that's when he's talking about a merger of the judiciary, these judiciaries
Hmm.
with one of the branches of government. In essence, he's saying two things. One, you're going to have the use of this power, and number two, you're going to have political influence.
Okay.
That's exactly what we have now. We have tort courts that are exercising this exclusive power or enforcing it rather, and then you have these political decisions coming out of these courts.
Right. Okay.
It's exactly what we have. Everything that he was saying in '78, we did not design the system to operate that way. So we read that, look at the system, say, oh, okay, we're not aligned with the Constitution
Okay.
at all, not
So
even close.
it looks like we're about, I don't even know what our time is. I'm assuming we started at 2:15. So I'm gonna end it here, and I'm gonna end it here after your closing comments if you have any. Um, that ended up putting us on 24, so we actually did 2 pages. I think there was a lot of information though in there that was worthwhile. And at least for me, if nobody else, if
No,
it's not
I
enough
am
for
really
somebody else.
glad that you asked the questions that you did, and you forced us to get down into the nuts and bolts of this because I probably could have done a better job explaining this in the book. Um, my problem was is I didn't know whether or not I would be beating a dead horse by over explaining, and I didn't want to over explain and treat the reader as if they're an idiot, right? So that's the thing about writing. You got to be careful. You're walking a tightrope between doing too much and not doing enough. And so I'm just glad that we spent the time that we did on those, because all of those things that I've written in there, they're in the book, and it's not written in passing. It's just it doesn't go into this level of explanation. So I'm glad we did that, because you're right. These things are critically important to understanding the situation that we're in politically now.
Well, if we're still in the beginning of the book, it's probably worth spending the time to be able to try to firmly lay that foundation. And,
Right.
I mean, I'll admit to even the viewers here that, there are some of the things after I've read it twice and I'm going through we're going through the videos, I'm still blindsided by how it all comes together. I'd like to think that I could be, a mini Ron and go off and give, presentations on the topic, but, I might be able to just throw bits and pieces out there just to arouse curiosity. And at this point, that's just about all I am right now. So hopefully, as we end up going through this, we can all become a little more articulate. And hopefully, the people that are viewing that haven't bought the book will take the opportunity to buy the book. If you're actually interested in buying the book, which we strongly recommend, you need to support Ron anyway. And if you like him, that's even more of a case. You need to buy 2 copies and then just give one away.
Well,
I
there's
bel
holidays coming up and all that
Yeah,
sort of
I believe you can buy the digital copy. I think you can actually buy a spiral bound on his website now. Ron Nielsen, his website is the history of federal lands in the United States.com. The link will be in the description box below the video. Take a look around the website. If you're looking to watch the whole series, there's a playlist there now where you can watch the other videos. You can encourage other people to be able to go there as well. You can feel free to contact Ron. Also, if you happen to be somebody that we're hoping for to help get his word out there about what he knows and how he can help make a difference, we're requesting that you contact him there for interviews as well. So, Ron, the author of the History of the United States, History of Federal Lands in the United States.com. Thanks for joining me, man. And I look forward to doing more of these videos until we get to the end of the book and maybe beyond.
Absolutely, brother. It's been a pleasure. Thank you so much.
All right, man. Thank you. We'll talk to you soon.
All right. Peace.